Hello, everybody. Mr. Kozak's here. 250039007, the people of the state of Michigan versus William Corbin.
Good morning, Your Honor. Kyle Peskulovich appearing on behalf of people.
Scott Kozak on behalf of Mr. Corbin.
Right, and Mr. Corbin, could you please state your full name for the record?
Jamar Corbin. Can you hear me, ma'am?
I can. Are you still using a mailing address on East Flint Street in Port Huron?
Yes, ma'am.
And just for purposes of today's court date, are you agreeing to appear remotely from the jail?
Couldn't hear you because I got people talking outside. What you say, ma'am?
I just said for purposes of just today's hearing, are you comfortable or agreeing to appear remotely using Zoom from the jail?
I'm so sorry about that. I couldn't hear you because I got people out here talking.
The connection is poor from the jail right now. I think he's getting every other word.
Mr. Corbin, are you okay if we continue to proceed on Zoom today?
Yes, ma'am. I can hear you now.
Okay, all right, great. Did you have a chance to speak with him despite the connection issues?
I did, Your Honor. And although we couldn't go through every piece of information, I will inform the court that I did try to visit with you yesterday, but the smart jail system is a little spotty right now. So I did have a chance to speak to him, get some initial information from him. I do have the initial written discovery. I'm going to ask counsel, and I'll contact him separately regarding any kind of media, audio or visual materials that may be available. So maybe Mr. Peskulovich can provide that in due course. We're going to ask the court to leave it on for the exam date for next Thursday. And so I think we can proceed on that date.
All right, so no need to discuss a time waiver. We have an examination date set for you already, sir. It's set in the afternoon next week on Thursday, the 18th. We could begin the examination on that date, which is a right that you are entitled to exercise to ask us to begin that hearing within 21 days of your arraignment. So we'll keep the date. Your attorney is going to continue to work with the prosecutor to get any and all discovery that may be appropriate to review for your exam. And I'll make sure that if you do remain in custody for the next week and you're there on the date that we're going to have the exam, that you're brought over in person to participate in the proceedings. Do you understand all of that?
Yes, ma'am. Can I say something?
But hold on.
Hold on, let Mr. Kozak try to address any issues you may have talked about before you place anything on the record. Is that all right?
Yes, ma'am.
Go ahead.
Your Honor, my client asked me to address this bond. It is currently a $10,000 cash surety bond. I do not believe there's a 10% provision. My client asked me to ask the court to consider a personal bond. I do not believe he was on probation or parole at the time or any kind of bond conditions as far as I know. He's indicated that he wasn't. I know this is an alleged third domestic violence offense. The client does have some other records to speak of some time ago. That being said, he does have a permanent residence with his mother in Port Huron. That's the address that the court has. He's provided me with a phone number to reach him. He also indicates that he does have potential employment while he's living there, and I think the distance would provide the complainant witness with a margin of safety. I do not believe if the court were to amend to a personal bond that he would be a continued danger to the community, at least.
And I can go back to work.
Okay. Is there a position that the people are going to take on this request?
Yes, Your Honor. People would object to any modification of bond. I believe the defendant's a public safety risk. This case involves allegations of a bystander calling the police because they saw a defendant in public striking a female victim. When police arrived, they saw the defendant allegedly standing over the victim as if he was about to strike her again. Victim had to be transported to the local hospital for her injuries that she sustained. And the victim reports to police that the defendant and her lived in a hotel or motel and panhandled for the last 8 months. So I have concerns regarding one, public safety, but also defendant's likelihood to return to court. If he had been spending the last 8 months panhandling and living in a motel, I don't understand how he suddenly, once incarcerated, has stable housing and work available for him.
All right. And I can tell you, although I don't have to review the magistrate's decision and determine that there was an abuse of discretion, I know that they considered the pretrial services report and recommendation that was presented at the time of the arraignment. Pretrial services did not recommended against release on personal recognizance. They cited both public safety concerns and a risk of failing to appear. There is an assaultive history. There's a lengthy history here, taking into consideration some of the sentences that were imposed on previous convictions. Almost all of it is assaultive in nature, quite frankly. And it looks like there's a recent allegation out of the 72nd District Court, domestic violence, in which your client received a jail sentence of 93 days that probably took him into just June of this year. So recently completing that jail sentence, and the listed victim in that case is unfortunately the same as the complaining witness here. There was also some verification that they attempted to do about residency and employment, and in conferring with the complaining witness, she reported that the parties are homeless and that they had been residing in and out of motels for periods of time over the last year. So I do have the same concerns, I think, that have been identified by the prosecutor. It is not the case where there is no bond. However, there is pretty significant concern about public safety, specifically as it pertains to the complaining witness. And then in addition, because I don't have the ability to confirm any of the information about stable housing or employment, I would not be inclined to make a change at this point. If you're able to document those things with the assistance of your client, you can revisit the issue when you come in next week. But based on the information that I've been able to review here, I wouldn't feel comfortable reducing the bond. I do think a significant bond is appropriate to ensure that if it's posted, I can verify the whereabouts of your client and that there's a significant enough financial obligation that he would have to the court or a surety company that would get him to return for all future court dates.
And I appreciate the consideration for your honor.
All right. So, Mr. Corbin, I don't want to allow you to then add to the record. I've already made my decision, but I did tell your attorney, hopefully you were able to hear me clearly, that if you're able to document some of what you're reporting about stable housing and employment, I'm going to see you next week. You can always ask me to review my own decision on bond. It is something that I am willing to change. I often consider these requests from people on cases. And if I find that there's an appropriate basis to change something that I had previously decided, I'll consider it. But I'm not going to do it today. So I'd like for you to just take this opportunity to follow back up with your attorney so you'll be prepared next week for your hearing date, okay?
Okay, so what I wanted to ask you was, ma'am, actually, I don't understand because she's not saying I did nothing.
Mr. Corbin, this is related to the case. The judge cannot answer those questions, neither can the prosecutor. This is a conversation that you and I need to have privately in the context of an attorney-client communication. So this is a question that I can't have you asking right now.
Right, and I do want to just remind you, Mr. Corbin, there is a no contact provision in place where you cannot have any type of contact with the complaining witness, Ms. Jenks in this case, and that includes telephone contact, email contact. If you remain at the Oakland County Jail, I just want to remind you that there's a very good possibility that any phone calls you're making, emails you're sending, these are reviewed by law enforcement, the prosecutions, investigators. So I just want to make sure that it's entirely clear that that no contact provision means no phone calls or emails as well. Do you understand that?
Yes, ma'am. I understand that. I haven't been doing that. What I don't understand is, ma'am, I'm sitting in jail and I didn't do nothing. And I don't understand. The police said I was hitting on her and I wasn't.
All right, okay, Mr. Corbin, I don't want to have to discontinue the hearing, but I did also see a note in here that at the time of the pre-sentence investigation, they had a lot of issues. It sounds like there was a lockup issue with uncooperative behavior. I don't want this to get us to a place where there could potentially be sanctions. I would like to close the hearing today, We're going to see you in court next week. Your attorney will talk to you. I know he will make arrangements to meet with you, and we'll address any additional issues next week. All right? Thank you, sir.
Thank you.
Thank you, Your Honor.
Thank you.
I love you all. Be safe, be well, sleep sweet, and much love.